Welcome to Ask the Lawyer radio podcast with attorney Brian Figueroa of the law firm Figueroa and Associates. This podcast features a recording of our most recent radio show aired weekly in New York City. We hope you enjoy the show, which features news, views, and interviews on matters such as immigration, personal injury, bankruptcy, divorce, family law, estate planning, wills and probate, deed transfers, civil rights, criminal defense, workers' compensation, and taxes, both individual and business. You can contact us at 855-768-8845 or visit us at www.askthelawyer.us. You have questions? We've got the answers.
ICE's new interim guidance on victim-based immigration benefits. U.S. Immigration and Customs Enforcement, ICE, has issued new interim guidance aimed at enhancing protections for noncitizens who are victims of crime, abuse, or human trafficking. This updated directive outlines procedures for officers and agents to consider when exercising prosecutorial discretion in cases involving individuals eligible for victim-based immigration benefits, such as UVisas, TVisas, and protections under the Violence Against Women Act, VAWA. ICE's new interim guidance on victim-based immigration benefits will discourages victims from seeking help, fearing detention or deportation, strengthens perpetrators who may exploit victims' fears, erodes trust in law enforcement, hampering community safety and criminal justice efforts. Victims seek proper legal representation immediately. Then a significant policy update dated January 30, 2025. U.S. Immigration and Customs Enforcement, ICE, released new interim guidance on civil immigration enforcement actions involving current or potential beneficiaries of victim-based immigration benefits. This move rescinds earlier protections and shifts enforcement priorities, potentially altering the landscape for immigrant survivors of crime, abuse, and trafficking. The guidance aims to balance enforcement with legal obligations while impacting how officers interact with immigrants seeking protections under laws like VAWA, T, and UVisas, and Special Immigrant Juvenile Status, SIJS. Purpose and scope of the guidance. ICE's interim guidance emphasizes four main directives. 1. Coordination with law enforcement to avoid disrupting investigations. 2. Special procedures for dealing with victims who are beneficiaries or applicants of victim-based benefits. 3. Limited officer obligations regarding identifying crime victims or considering victimization as a favorable factor. 4. Restricting expedited processing requests, shifting them to discretionary, case-by-case basis. This guidance does not revoke the congressionally established T or U visa programs, nor does it eliminate the bona fide determination, VFD, process. Rather, it alters how ICE officers should approach enforcement concerning such individuals. Key changes and concerns. 1. Coordination with law enforcement. ICE now instructs officers to coordinate with local, state, or federal law enforcement to prevent compromising ongoing criminal investigations. This aspect seems designed to prevent conflicting agendas between immigration enforcement and criminal justice efforts, especially when the immigrant is a cooperating witness or victim. However, ambiguity remains. It is unclear what appropriate coordination looks like or how to implement internal deconfliction. Practice implications. Legal practitioners should track their clients' involvement in any investigations. Victim witnesses should be connected to victim rights attorneys and local advocates to assert their protections. 2. Enforcement against victim benefit applicants. ICE officers are encouraged to consult with the Office of the Principal Legal Advisor, OPLA, before taking enforcement actions against individuals with pending or approved victim-based benefits. However, this consultation is not mandatory, which may leave beneficiaries vulnerable. This policy includes those with pending or approved T and U visas, approved VAWA self-petitions, individuals with BFD status, derivatives of primary applicants, practice implications, carrying documentation, BFD notices, approvals is critical. Attorneys should prepare for possible enforcement by organizing stay of removal forms and filing fees in advance. Notably, individuals without BFDs or who are inadmissible remain at significant risk, especially if they have prior removal orders or criminal convictions. 3. No obligation to identify victims. Perhaps the most controversial update is that ICE officers are not required to identify potential victims of crime or consider such evidence favorably. This provision reverses the more protective 2021 Victim-Centered Approach memo, which encouraged officers to view victimization as a mitigating factor. Practice implications. Victim documentation, protection orders, affidavits, should still be presented during proceedings. Advocates must argue for humanitarian, public safety, and administrative efficiency to counterbalance this policy gap. The DOJ's 2024 regulatory updates still empower immigration judges to administratively close or terminate removal proceedings for individuals with prima facie eligibility for victim-based relief, even without applications being filed. 4. Expedited adjudications. Previously, ICE frequently requested expedited USCIS adjudication for immigrants with pending victim-based benefits. The new guidance ends this practice as a default, now allowing such requests only when it serves ICE's best interests. This could slow down protections for vulnerable individuals, potentially exposing them to detention or deportation while waiting for USCIS decisions. Practice implications. Advocates must assert congressional intent to safeguard victims in expedited adjudication requests. Emphasizing public interest and cost-saving benefits may support requests for prioritization. Legal safeguards and 8 USCSS 1367 protections. Despite the stricter enforcement stance, ICE reiterates adherence to 8 USCSS 1367, which mandates confidentiality and protects against the use of victim-related information in enforcement actions. This includes strict limitations on arrests at sensitive locations such as domestic violence shelters, courthouses in relation to relevant legal proceedings, victim services centers. ICE must ensure these actions are justified and documented per statute. However, the guidance fails to clarify enforcement in non-specified locations or ICE check-ins. Practice implications. Practitioners should scrutinize any enforcement action for compliance with these statutes and pursue advocacy or litigation where violations occur. Broader implications. The new guidance, while framed as procedural, reflects a broader shift in ICE's posture toward immigration enforcement, one that potentially undermines the intent behind victim-based immigration protections. By rescinding prior compassionate guidelines and removing proactive responsibilities from officers, this update discourages victims from seeking help, fearing detention or deportation, strengthens perpetrators who may exploit victims' fears, erodes trust in law enforcement, hampering community safety and criminal justice efforts. This shift, combined with other rescissions like protections at hospitals and social services, could contribute to a chilling effect where vulnerable noncitizens hesitate to report crimes or seek safety. Conclusion. The 2025 interim guidance by ICE represents a pivotal change in the approach to immigration enforcement concerning crime victims. While it retains some legal safeguards and nods to statutory obligations, it also reduces proactive protections, weakens procedural barriers, and raises concerns for the legal and immigrant advocacy community. Legal practitioners, advocates, and immigrants themselves must remain vigilant, well-informed, and strategically prepared. Coordination with allies, thorough documentation, and understanding evolving policies will be key to navigating this shifting landscape.
Do you have a legal issue, question, or concern? Turn to Ask the Lawyer. You have questions?
Our weekly
We've got
immigration news
answers.
roundup is brought to
For
you
a
by the law firm
consultation
of Figueroa
or to
and
refer a
Associates.
client,
For a consultation
visit
on any immigration or legal matter, please call
www.askthelawyer.us.
855-768-8845.
Again,
That's 855-768-8845.
You can also register for our paralegal program, get legal news, business consults, or other information on educational issues. Yes, ask the lawyer. You have questions? We've got answers. For a consultation or to refer a client, visit www.askthelawyer.us. Again, www.askthelawyer.us.